Good afternoon. Today I'm going to consider a very important company law case, which all corporate lawyers will need to look at closely, I suspect, in the next year or two. Case is Wambo Coal and Sumiseki Materials, 2014, New South Wales CA 326, judgment given in the middle of September this year. And one may say so, it's an absolute tour de force by Justice Barrett, running over some 65 pages, looking in detail at the question of payment of dividends, rectification of a company's constitution, and oppression suits. And the case arose in the context of a claim by Sumiseki for a particular dividend to be paid to it, which it said had been guaranteed in terms of the class of shares which it owned when entering into a joint venture with Peabody. Became a shareholder, and it said that there was a provision which required it to be paid a fixed amount of dividend. That of course raised an important issue for the Court of Appeal as to whether or not you could, by agreement as it were, fix the amount of dividend paid in advance, and whether if you attempted to get around that requirement by perhaps altering the amount of capital or the amount of profit made, then whether or not that was an oppressive action under Section 232. And there was when the venture was started, two shareholders of Wambo Coal, and Sumiseki held 25 million B-class shares, which were all the B-class shares on issue, and Peabody held all the ordinary shares. And an Article 2.1 capital B was inserted into Wambo's constitution pursuant to what was called a restructure agreement, and that provided that a holder of a B-class share, that's to say Sumiseki, had the right to receive a dividend in respect of a 6-month period commencing at a particular date and ending at a particular date, equal to a particular fraction of an amount equal to the profit of the company available for dividend purposes. That raised, of course, the important question of what was the dividend, what was the amount of profit available for dividend purposes. And the directors had power to declare and pay interim and final dividends, as in their judgment the final position of the company justifies, and in the usual way to capitalise profits and effect bonus share issues. And Wambo's directors decided not to pay B-class shareholder dividends in respect of particular time periods. And naturally enough, Sumiseki took front of that and brought proceedings in the equity division, and they sought various declarations with respect to the right to be paid the dividend, regardless of any decision which the directors had made, and also an argument that Wambo's failure to pay the dividends in the context of their agreement fell under the oppressive conduct proceedings pursuant to Section 232 of the Corporations Act, and that therefore an appropriate order for relief should be made under Section 233(1)(b) to vary the Constitution. So, what were the issues? Well, first of all, whether or not Wambo's Constitution, as properly construed, entitled Sumiseki to the right to receive a dividend in respect of the periods calculated, to the exclusion of any discretion given to Wambo's directors with respect to dividends. Alright, so a fundamental issue there, which will be very important, I think, for a lot of company structures. Directors, of course, are charged with the execution of the company's business. Decisions about dividends, on one view, it remained entirely within their discretion whether to declare a dividend out of profits, but could you override that, as it were, by some particular stipulation? Secondly, whether or not a decision not to pay dividends amounted to oppressive conduct. And thirdly, whether or not the trial judge, Justice Hammerschlag, should make various orders with a view to altering the company's constitution. And I suppose ancillary to that was an important question which has been lurking for a long while in company law as to whether there was a jurisdiction in equity to permit rectification of a company's constitution. And the trial judge held that in this case there was no such equitable jurisdiction, and the Court of Appeal agreed with him. You still can't rectify a company's constitution. So, now, what did the court hold? Well, first of all, the court held that with respect to distribution of profits as dividends, that of course is usually a matter for the internal management of the company. But on the proper construction of Wambo's constitution here, the B-class dividend which Sumiseki was enjoying was a mandatory dividend that became payable by Wambo on each date for payment specified, regardless of any decision that it should be declared or paid, and the company was obliged to pay accordingly. And there's a great deal of analysis there by Justice Barrett, which we'll come to in a minute, looking at that question as to how the particular provision operated. Secondly, on a proper construction of Wambo's constitution, profits available for dividend purposes referred to the period's net profit attributable to members, undiminished by any discretionary applications of a director's power, but subject to any diminution, if any, as required by law. And with respect to the decision not to pay Sumiseki for dividends, it was held that Wambo was entitled to receive during the period, in some periods, to adopt contractual risk constraints, and that was in fact oppressive conduct, and that would constitute oppressive conduct under section 232. And then, as I've said, not possible to actually exercise any equitable jurisdiction. Now, an important judgment, as I said, runs the hundreds of paragraphs. Justice Barrett is main judgment writer, as you'd expect, for the top company lawyer, and Chief Justice Bathurst agrees with him, as does Margaret Beasley as the President. And the judgment is one which can't be summarised very easily, but His Honour looks in tremendous detail at all the relevant cases, and there are lots of them, of course, looking at, first of all, the payment of dividends, which can only be paid out of profits. And as he notes in paragraph 57, the new form of section 254 capital T of the Corporations Act, introduced in 2010, did not maintain the statutory rule that dividends must not be paid except out of profits. The revised section 254 capital T prohibits payment of a dividend by a company unless there's an excess of assets over its liabilities sufficient for the payment of a dividend. The dividend is fair and reasonable to shareholders as a whole, and the dividend payment does not materially prejudice the company's ability to pay its creditors. But it may be that there remains a general law principle that dividends may only be paid out of profits, given the essential nature of a dividend as a share of profits. And His Honour then goes on to look at all the requirements with respect to accounting for profits, which will be of great interest to those company lawyers watching, and also, of course, questions of accumulated losses and special capital accounts. He discusses that at paragraph 68, 69 and following. In the payment of dividends, he discusses at paragraph 73 and following, and section 1241D of the Corporations Act empowers a company to distribute any of the company's property among its members in kind or otherwise, and section 254T, as I said, has already been mentioned, as His Honour mentioned at paragraph 57, and imposed prohibition upon paying dividends unless a particular provisions were satisfied. Now, he says at paragraph 78, whereas here the rules in 254U and 254W do not apply, the processes by which dividends are quantified are those prescribed by the Constitution, construed as a whole. And he says, legal literature is replete with statements about differences between interim dividends and final dividends, the process of declaring and paying dividends, and the respective roles of a directors and company in general meeting in the process of releasing profits by way of dividends. These rules reflect not only rules of law, but effects of commonly encountered provisions of company constitutions at different periods of commercial history. And it says in paragraph 81, a company's constitution made apart from traditional form under which decisions whether dividends are to be paid, and if so, when, in what amounts, on the director's recommendation. Although a dividend always involves a payment by the company, and the function of paying falls to the board of directors or a delegate, the Constitution itself may set the dividend amount and require that it be paid, thereby removing those matters from the scope of internal decision making, and in particular from any process of declaration for which the Constitution provides. Well, there you go. So, although I guess when I was studying company law, I was always taught the directors had an absolute discretion to declare a dividend or not, and there had to be a profit before you could declare one. This judgment suggests that in certain circumstances, as appropriate, section 254 capital T of the Act might permit you to actually prescribe as a matter of contract what the particular provision is. And Justice Barrett summarises his finding at paragraph 94 when he says this: no consideration of principle stands against the recognition of mandatory dividend rights. The fact that on a particular future occasion performance of obligation to pay such dividends may conflict with the legal prohibition in section 254T or raise issues under section 588G does not preclude such recognition. any more than the theoretical possibility that some unforeseen statutory obstacle will in future prohibit performance of any contractual obligation precludes the making of the contract by which the obligation is created. Righto. Well, interesting, isn't it? A very interesting case, because I'm not saying it upsets a lot of company law, but it certainly clarifies, I suppose, some fairly important matters which have been regarded as perhaps not controversial, but as perhaps not entirely clear. And his Honour then at paragraphs 106 and following goes on to look at what the actual contractual right is here with respect to Sumiseki's shares. And we won't look at that. He's done lots and lots of paragraphs discussing the particular provision and also the question of profits. And as I've said, he comes to the conclusion that Sumiseki is entitled to receive a particular amount, not a small amount either in terms of profit, as calculated in terms of the particular contractual formula. And he then turns to look at the question of oppression, and he comes to the conclusion, look at paragraphs 182 and following, that in this case there was oppression by virtue of the way in which there had been decisions taken by, by Peabody to ensure that monies were not available for distribution, or there may be some issue in terms of actually having some funds available. And I won't summarise that, but he's on looks at that in great detail at 196, 197 following. And at 200, his Honour says that Wambo and Peabody took exception with the primary judge's resort to a legitimate expectation of receiving Class B dividends. And they said that that might raise questions of subjective interpretation, whereas we've always got to look at the objective position here. And so there's no real notion of any legitimate expectation operating. But if we look at the question of oppression generally at 205 and following, his Honour comes to the conclusion that there was an attempt here in terms of various matters of commerce to influence the availability of monies which would otherwise be available for dividend. And once again, I won't attempt to summarise it, you have to look at it in detail, but his Honour concludes at paragraph 222 that an objective appraisal of the circumstances as a whole leads comfortably to the conclusion that the contractual provisions restricting payment of dividends by Wambo was not born of any compelling commercial requirement of Wambo or Peabody, or of any rational desire of either party to adopt arm's length terms for the sake of adopting arm's length terms. It was rather a calculated reaction to the lack of success in attempt to persuade Sumiseki to agree to modification of the B-class dividend rights to its disadvantage. The revised loan agreement was used as a method of forcing or attempting to force Sumiseki, as a matter of fact and commercial reality, a position with respect to enjoyment of its legal rights, to which it declined to agree. And therefore, there was some oppression. Now, his Honour then looks at the question of oppression remedies. You can read that, paragraphs 229 and following, in terms of what sort of orders could be made. And he then turns to paragraph 240 and following to look at the question of whether you could rectify a particular constitution. And of course, there's various provisions in the Corporations Act dealing with acceptance of constitutions and the like. And he comes to a conclusion in relation to the special statutory nature of the contract between the members that it's not capable of rectification. And he concludes that at paragraphs 257 and 258 and following. So, a very important case, I think. Probably I've inadequately summarised it there, but it seems to look closely at questions of declaration of dividends, first of all, directors' power with respect to them, and perhaps preeminently and most importantly whether or not it's possible by contract to in a way foreclose the director's discretion. Can you in fact bind yourself? And in this sort of situation where there's a restructure of sorts going on and new capital is being injected, I guess the person injecting the capital wants some assurance that money is going to be paid out, and in that context it no doubt behoves them to protect their interests by inserting a particular clause in respect of dividends. So, important case, I think. Read it closely, and I guess it will certainly assist people who are trying to structure agreements in a way which protects the interests of those putting capital in, if in fact payment out by way of dividend is the way in which the money is going to be repaid.